Good afternoon and welcome to the latest installment of the Law, Technology, and Warfare Research Cells webinar series here at the Air Force Academy. Today, I am pleased to have with us Mr. Matthew Linton, the General Counsel for True Anomaly, who will be speaking to us about practical space law and the legal and regulatory challenges faced by space companies in the national security space. I have to admit, I have already heard this presentation because I actually failed to hit the record button on Zoom, and what you're hearing now was recorded after the presentation. But I have to say, having heard it, that you are in for a treat because what you are about to hear is one of the best, if not the best, surveys of the regulatory landscape that I have heard. So before we get started, I do have a couple of announcements. First of all, I want to remind you all that here at the Air Force Academy, we co-host with Space Command a space law legal conference, which will be from the 25th through the 27th of February in 2025, so we hope to see you all there. Second, while this is the last webinar of our 2024 calendar year, we already have great things in work for 2025, including in early January, we're going to have a podcast from the General Counsel of Quantinuum to talk about legal and regulatory challenges of quantum computing. And later in the month, we're beginning a mini-series on nuclear fusion, a webinar series, where we will talk about legal and regulatory challenges faced by companies in the development and commercialization of nuclear fusion. Finally, just a couple of notes before we get started. First of all, there is no federal endorsement intended or implied by the existence of any speakers on our series or content of what they say. And finally, all of our speakers, panelists, and presenters, including myself, are speaking in their personal capacities, and their views and statements do not necessarily represent the views of any governmental agency. So with that, I do want to introduce to you our speaker today, Mr. Matthew Linton. He is a 2006 graduate of the Denver Stern College of Law, and he has had a prolific legal career spanning both governmental and private practice. He's worked for the Department of Labor, the Social Security Administration. He spent many years in private practice doing corporate counsel and litigation work. And most recently, before his current position, he was an Associate General Counsel at Lockheed Martin for space operations. Now, like I said, he is the General Counsel of True Anomaly, which is a startup space company here in Colorado. With that, I hope you enjoy the presentation, and thank you all for being here today. Like I said, I did cut off, unfortunately, the first few seconds of his presentation. Most of it is there, and I'm sure you will enjoy it. Thank you.
A taste of some of the issues. One of the interesting things at the outset to say is that I think really many space companies, if not all, but particularly a space company that wants to do national security work, the legal issues that arise are just cross practice area in so many different ways that you might have some experience in one particular area or another, but there's probably no one that could claim to be an expert in all of the areas that are implicated when just looking at the regulatory side of this part of the picture here. And so I actually come at this with an immensely sort of humble approach, in that when I first joined True Anomaly about 2.5 years ago, pretty much everything that I confronted was novel in some particular way. And I have had the privilege over these last couple of years to work with many counsel, both outside and many folks within the government, within our regulators, to frankly learn where we are, try to figure out where we need to go, and then help at least our company navigate and build the pathway to where we're going to ultimately serve the interests of the U.S. government and its allies with respect to space security. So I will jump right in. We will have time for questions at the end, any question is fair game, and please don't hesitate to jump in and ask. So just here we go. Let's switch to the next slide here. So here's kind of the general overview of what we're gonna cover today. We're gonna start with some of the basics on the U.S. regulatory framework that applies. We're gonna hit some very basics on FAA licensing, relaunch, FCC side of things, NOAA and remote sensing, the export control issues that we confront, some of the compliance strategies that can be used in that arena, government contracting considerations, security clearances, classified work considerations, how we look at compliance in that arena, and ultimately, how we innovate in this kind of mixed environment of both very prescriptive regulatory requirements when it comes to things like export control in many ways, and also a very much unknown playing field when it comes to other areas of space launch authorization, space operations authorization. Again, particularly when you're serving U.S. government interests. And probably makes sense to give you all just a little background of the kind of company we are, to give you a little more flavor of how these things come about. But ultimately, True Anomaly is focused its mission on building out both a software and hardware solution, the hardware being our Jackal platform, our satellite platform that we have developed, which is a highly maneuverable inspection, reconnaissance, and characterization system, combined with our Mosaic software for everything from ingesting space domain awareness data, command and control of both our satellite as well as other non-True Anomaly satellites, and offering wargaming, range operations, all within the Mosaic software. The company was founded by four Air Force, Space Force folks that came out a few years ago, hoping to develop solutions to some of the problems that they saw were in front of our guardians. And the way in which the company was developed was really squarely from a sort of space doctrine approach that they had worked on while in the service, and thinking sort of from a first principles as to the kind of systems that might need to be developed in a rapid way, outside of the more traditional long lead defense procurement system, in a way that could get these capabilities into the hands of the warfighter as quickly as possible. And so, one way to do that is to go out, get private capital. We are a venture capital backed company, and we have developed our solutions with private capital such that we have both de-risked the cost to the taxpayer in doing so, but also applying a very classic kind of tech industry, Silicon Valley model to field systems rapidly, and to test, retest, fail, fix it, fail again, fix it, right? That's the approach that we take. And the goal here is that we're going to have something that is ready and capable right from the start. And we have an upcoming launch just around the corner of our next Jackal satellite that hoping for success there, and so keep your eyes open in the coming weeks here. Okay, so when I joined the company, and I joined very early as a lawyer for a startup. I think I was employee 18 or 19. The founding team looked at developing a privately funded space security platform, and said, yeah, we're probably going to have some legal issues. And so we they rightly so started mapping what they thought were going to be some of the needs for the company, really to kick off right from the start, before we even had a final satellite design. We started thinking about how we were going to get our system authorized for launch. Our first two Jackals launched last March, and they, from sort of inception to launch was about an 18-month period. And if are familiar at all with some of the timelines involved, typically with the kind of just basic regulatory authorizations that you might need for spectrum at FCC or remote sensing through NOAA, which we're going to talk about in more depth here today. The timelines don't really add up if you need something authorized literally, within a year or so of the spacecraft being a blueprint, in a CAD system. And so it's been quite an interesting ride. And here's some of the agencies. These are sort of the primaries that we, as a spacecraft or satellite company, work with. And you'll see, FAA is something where we don't have a ton of work at the moment because we aren't seeking launch authorization. Where we come in at FAA is something called the payload review process. We'll talk about that a little bit here as well. At FCC, we have to go out and get our spacecraft licensed to use the spectrum we need to use. And that also includes FCC's current authority over orbital debris and the analysis required to prove that we'll be able to deorbit appropriately and without causing dangerous space debris. NOAA, most people, particularly some of our investors who we educated early on, asked us, what the heck does NOAA have to do with a national security space company? And the answer is, well, actually quite a lot if you're going to be doing imagery. Because the original Land Remote Sensing Act, as it pertained to spacecraft looking at Earth, gave NOAA's office the ability to license commercial spacecraft doing remote sensing imagery. That authority has been extended to non-Earth imagery, which if I don't believe I was entirely clear a moment ago in saying that the Jackal spacecraft is focused on non-Earth imagery of other artificial resident space objects, other spacecraft to provide the kind of intelligence and understanding of those other spacecraft that our guardians need to provide the information back to who may need it within the government. And so NOAA has seen some interesting and very favorable regulatory reform a few years ago that has made the work with that agency really very successful for us and productive. And I'll talk a bit more about that as well. And of course, no space company or national security related company can make it through the day without thinking about export controls. It's a topic that gives most people heartburn, myself included. And we have to navigate the ITAR, the EAR, and how we classify our spacecraft and how we then can assess how we can work with other foreign providers of components potentially, and then ultimately how we may be able to work with other allied nations to support their space defense efforts. And DoD plays a significant role in all sorts of ways, as I'm sure many of you know. And this is an area where frankly, there's always an information gap for someone like myself who was not fortunate enough to work within DoD. I was not a JAG attorney, and so I'm always myself learning more about the way in which we, the military council, many of you all on this call, support your clients, and how we as a commercial company can find ways of not running afoul of the kind of considerations that you all need to look at when assessing your client's work. And of course, there's the entire clearance side of the equation. And as a early stage company, we are many of our folks have clearances from previous work. We are ourselves getting the company its clearance imminently, and will have all of the administrative burden that is associated with that. And then NASA plays a role in various ways for some of the things that we do, but particularly when it comes to coordination. If there's any FCC folks on the call, I think you'll appreciate some of the complexities at times of coordinating with NASA, because if you are serving a government mission but as a commercial entity, and doing the kind of non-Earth imagery that we're doing, we have overlap in the different kinds of spectrum bands that cross into some government frequencies that can get a little funky. Okay, so I will say that I'm fortunate that I don't have to deal with launch authorization licensing because we're not a launch company. So I really put this here for as a placeholder to make the point clear that if you are advising or considering a launch provider's needs, the FAA licensing process is an interesting one. And the oversight that is there with respect to commercial space flight under Part 450 of the federal regulations here is really it's its own area of law. It requires its own specialized understanding of in relationships, quite frankly, within FAA to be able to navigate its review process, which includes a host of interagency aspects in terms of environmental reviews that are required for launch. And you'll see stuff about this in the news when companies like SpaceX and others talk about their FAA licensing. And so if for a startup, probably day one you should be thinking about engagement with the AST office at FAA to understand how they're going to look at your company and what you're providing. And you are likely going to need a pretty robust team of safety, environmental folks as well to really be able to properly navigate and seek the authorizations needed here. When it comes to a satellite, and if you're in the government side, right, I think it's good to understand and kind of get up to speed on the challenges that your customer really might face here. And, of course, so many folks are working with SpaceX and they have kind of got this down in many ways, but as we see, hopefully, many more launch providers kind of make it over what is called the valley of death in the startup world and get to, consistent, safe, and reliable launches. Understanding the regulatory administrative process that they have to go through as on the if you're the government customer, I think is really critical, because you might be able to even help move things along potentially. For a satellite company, we have the payload review aspect, which your launch provider typically will file on your behalf. We at True Anomaly have worked our first launch with SpaceX and on a ride share, and they essentially submit your information and your payload. If you've already been licensed by FCC for spectrum and orbital debris and NOAA, you tend not to have many questions from FAA because they can rely on for particularly the orbital debris analysis and the understanding that one of the things that they're going to be looking for very much with scrutiny is the kind of payload that you're flying. And if you're not flying something of some particular safety sensitivity like a nuclear payload or something that could rain debris down over a populated area should there be a launch failure, right, you're going to be able to move through pretty quickly. But understanding that payload review process as a satellite operator is important to kind of know how much you need to lean in beyond the launch provider's side of things. So, the big one here that we have to deal with is FCC. I was not an FCC lawyer, nor am I an FCC lawyer. And so when I joined True Anomaly, we partnered with some really terrific folks to help advise us as to the way in which we should approach licensing our spectrum needs. And 2.5 years ago, it was actually a little less clear. It's a little more clear today as to how you might want to approach it, partly because of a work that the FCC is doing for smaller companies and what they call their transparency initiative to try to provide more insight into the process. And so, again, I'm really kind of touching the real high points here. And we can certainly dive in on questions if there's specifics. But, if you're a private satellite, right? So think of our mission again as, all right, we're paying for our satellite. We own our satellite. Your company owns it, and you're going to launch it, and you're going to operate it, but you might sell your service of that satellite back to the U.S. government in some way. You're going to need to likely go get a commercial license here through the Federal Communications Commission to do that, even if your mission is a government mission that you are performing. If you are owning and operating on behalf of that government mission, you're going to almost certainly need to work with FCC, who is then going to help you sort your way in which you might get a license. There's different avenues for sort of prototyping and getting your spacecraft up quickly. There's the experimental Part 5 part of the FCC process. What's called a special temporary authorization may be an avenue. And you really, all I can say is work with a space knowledgeable law firm and engineering firm, or some law firms have built-in in-house RF engineers and debris specialists as well that can help you sort of package your application. But FCC is going to be managing determining your allocation. And to be clear here as well, there's no allocation made for low Earth orbit spectrum for the kind of maneuverable satellite platform that we have. And so it's all somewhat a bit messy in how you go through this process, and really need to understand your use of the spectrum and the different bands that you're using and how they may interfere with government systems and others to be able to get it over the finish line and show that you can safely conduct your operations. FCC also is going to have its own coordination process behind the scenes through NTIA, the government entity that handles its own use of spectrum. And one area that we've seen is particularly challenging is the NASA need to have no lack of interference on its deep space network, and trying to ensure that we can operate in bands that could interfere, but in ways, if we can build our operations that they don't, allows us to get these systems fielded, because ultimately we are going to be serving the U.S. government at the end of the day. So you work through FCC, they'll say get your license in. The time frames can be quite long. Ideally you're getting it in 8 months, a year in advance. If you're building your spacecraft to fly, again, 8 months after from design inception, that's a challenge. One of the big challenges right now, I think, for space startups, particularly space startups that are seeking to solve very urgent national security needs with private capital, which the DoD has encouraged through its commercialization of space strategy. You're bumping up against timelines within the regulator that are just not going to work. And if it typically takes 8 months to get an authorization. There's a lot of interaction that needs to occur directly with the agency. And I would say to folks, if you want to go, try to represent a startup space company, get comfortable talking to a lot of federal agency bureaucrats who are really good folks that are trying to do the right thing, and are often working within regulatory regimes that are just not set up to address these more urgent needs. But we work through it. We successfully have worked through it, again with good counseling. And so, the earlier you can get into your frequency coordination, the better. The earlier you get your license application out, the better. And also understanding the other side of the FCC process, which is the International Telecommunications Union side, where your spectrum needs are published internationally, and then you have additional coordination that occurs with respect to the use of spectrum internationally. And on top of that, you've got to make sure that your ground station providers, we work with several, that those ground station providers are lining up their licensing process as early as possible so that you can actually use the ground stations all around the world that you need to be able to work, actually operate and communicate with your spacecraft. So I mentioned the FCC Transparency Initiative. In addition to this transparency initiative, oh my God, it may have been close to 2 years ago now, the FCC reorganized into what it calls its Space Bureau to bring some more energy and resources into direct space regulatory authorization needs. I think they continue to have a work in progress, but this presentation, which I assume will be available to you all, will have links where you can click through and actually read some of these things, and to kind of see where the regulators are going. I actually will back up a second because I neglected to mention the National Space Council last December put out what it called, I'm just going to go back a couple of slides, the Novel Space Activities Authorization and Supervision Framework. This is led by Diane Howard, who some of you may know. And the Novel Space Authorization Framework really set out principles, as well as a legislative proposal, which did not, get through Congress at this point, but at least attempts to set out some concrete proposals for why and how the vast breadth of administrative agencies across the U.S. government, how they should really coordinate and work together, but particularly the Department of Commerce and the Department of Transportation, and of course NOAA falls under Commerce, to better establish a framework for companies that are doing novel space activities. What is a novel space activity? Well, a rendezvous proximity operation for the purpose of inspection and characterization is generally kind of the novel space activity. So that's we kind of fall into this arena. There's kind of a distinction as well between ISAM, or servicing, and the more intelligence focused and surveillance focused capabilities of a national security platform like the Jackal. All right, NOAA. So NOAA, through its authorization to regulate remote sensing, regulates non-Earth imagery as well, and the ability of a spacecraft to RPO and image another spacecraft until very recently was considered pretty sensitive. It's still considered quite sensitive, right? But it's something that is, the idea that commercial platforms are going to do this, are doing this. Some companies have capabilities already in this arena. There are, of course, U.S. government platforms where this traditionally, has been something that wouldn't fall under NOAA's jurisdiction. But if you're a commercial company, you're going to have to work through NOAA. What does NOAA do? Well, they do actually do a lot of things that are quite helpful and useful in many ways as a storefront to a company seeking to provide these kind of solutions. So when you go to NOAA to get a license, it comes in the form of a license to conduct your imagery operation, whether it's traditional remote sensing or non-Earth imagery. NOAA is going to first seek to understand, the precise capabilities of your sensor system, right? The resolution, etc. When you get straight on, what you can do, NOAA is going to look at how they have different tier levels, how they might classify you in terms of the kind of conditions that would apply to your license. And if your sensing platform, is essentially less than or equal to equivalent foreign capabilities, you're going to have a lower restriction. If you exceed known foreign capabilities, you're going to have a higher level tier restriction. That is going to include additional conditions as to how you take your imagery, and when you might be able to take your imagery, the kind of contacts you need to have for keep out zones and times in which the U.S. government may not want you to take that imagery. And one of the things that NOAA does that is, again, quite helpful and useful is they are vested with the, again, sort of storefront approach of working through an interagency process that includes DoD space policy folks, that includes the intelligence community, to essentially run the traps across all of these different stakeholders within the U.S. government to determine, hey, are we going to let these folks do this or not, right? And if we're going to let them do it, how are we going to let them do it? And what kind of, data protection measures and encryption need to be on board? What kind of cybersecurity protection needs to be on board? They're going to look at this in a pretty comprehensive way. And my just, limited lawyer brain at times struggles to understand, the way in which you assess the optics and resolution. And thankfully, these are areas, again, where it can be a fun area of practice because you really are working with some very smart and talented engineers, and then at the same time, space operations professionals who are going to build out the kind of ConOps and other descriptions of your mission to really work with the regulator to get the authorization. This satellite, this is an AI generated satellite, FYI, rather than use either our own or anyone else's platform. So enjoy the AI imagery. It's got one heck of a giant camera on there, which is kind of fun. And it's not looking at Earth, so I don't know where it's going. Looking somewhere out into the universe, this coordination process with the various national security interests can be a bit obtuse. And again, working with the government and not against it is my number one recommendation here, which is build the relationships with the agency. They are quite available to discuss questions, concerns, and help map really from the outset the way in which you might approach a licensing process. And I think for a lot of early stage companies, it's really hard to understand and get to that level of, oh, wait, so what we need to do is actually engage directly with these U.S. government officials to be able to do what we want to do. I think I'll talk about this a bit more when it comes to innovation. That can be a hurdle. So we'll talk more, and at the same time, the next hurdle. So we'll transition here to ITAR and EAR, everyone's favorite topic. Let's again, going to hit the basics here. And you may or may not have any familiarity with this. I suspect most of you have some familiarity to a degree. But the export control regime in the United States is really split into these two categories of ITAR and EAR. ITAR is handled by the State Department. EAR is handled under the Commerce Department. ITAR is going to have specific areas of technology identified on what's called the U.S. munitions list. You can look it up and look at each category, and it at first glance might appear that it's something, okay, so I've got a thing and it does X. Let's go pull up the ITAR, and we're going to go down and, okay, I'm going to go to the spacecraft section, and I'm going to start reading. Spacecraft that can do this, this, and this are going to be on the list. Well, the problem is there's always ambiguity in the way in which these technology items are described. And there has been some reform in recent years, and there's pending reform in the space arena right now on a rulemaking that has been proposed to move a few more things out of the ITAR. A few years back, certain spacecraft capabilities were moved from the ITAR to the EAR. What's the EAR? Well, EAR is arguably a little easier. You still are regulated, you still have export control, but it's managed through the Department of Commerce, where you're supposed to, what's the Department of Commerce's purpose? The purpose is to facilitate the commerce of American business. So commerce is a little less restrictive, is a little more permissive to enable, for example, getting a license if you need to work with some non-US person supplier that you may need to share technical detail with to have something either manufactured for or otherwise made compatible with your stuff. And it's going to cover, as you can see here, what are called dual use items that are not on the US munitions list. A dual use item, if it's not something you're familiar with, is ultimately something that can be used both for a military and a commercial purpose. Our Jackal platform is a dual use platform. It can be used for commercial safety and security missions on behalf of commercial operators. It could be used for non-military purposes by even U.S. agencies like NASA. But of course, we are very much building a product that can be used by the Space Force and the U.S. military for specific military applications as well. And so you really have to look at each version of your platform that you develop and assess which might be classified in which way. Nobody can really do this alone. It's something that you need both engineering and legal insight into, as well as potentially, if you're looking at something like a foreign military sale, there are going to be folks within the Pentagon you're going to have to work with to assess the way in which you might engage in a foreign military sale. And so the challenges are actually quite significant because trying to self-classify one's technology with respect to export control does require significant investment in time and specialty and knowing and understanding every piece and part that comes from every vendor into your platform in your materials to really understand how things might be classified. And there is a way in which you can go directly to the State Department, right here, I think I've got it, to get what's called a commodity jurisdiction request. You can go out and say, okay, look, here's what we think, but you tell us whether or not you think it's on this USML or not. As you might expect, going to the government and asking them to tell you something is not often the best route if you are trying to get it classified in one way or another, or you believe you have it accurately classified. And again, we talk about timeframes. So, our company is seeking to field systems. Again, we're on our second launch, third satellite, 2.5 years after the company was founded. Commodity jurisdiction requests can take up to 2 years just to get the answer. So that's the entire existence of our company thus far. So it's the timeframes of government review um, simply don't line up to the rapid need for technological development in the space arena. And that is the case across direct space regulators like FCC. NOAA now has a 60-day requirement for their review, which is beautiful. I'd love to see that across every agency. But then you go into these traditional, reviews like State Department reviews, and just you'll be lost in the process. How that being said, expensive legal advice can help move the needle with the right relationships that some firms might have. And so when looking at a company that is engaged in these kinds of activities that are potentially covered by ITAR, EAR, it's really important to have an understanding of who you will deploy to help you with each given agency. And different law firms have different expertise and different, you're not often going to find it all in one place. So although some are working to build more defined space practices that kind of cobble these different specialties together. Okay, let's see here. I just want to pause and make sure I don't think there's any questions or anything at the moment, so I'll keep running here. So EAR, I mentioned it already a bit, right? You're covering dual use items not on the USML. You will also similarly look at a chart of classification of technology, make an assessment of where your item appears, and then handle it accordingly. Once you've really kind of figured out your classification of the technology you have within the company, the compliance side becomes huge. Well, it really starts from the beginning, even while you're working that classification. But then you must assess every aspect of the way in which your technical data is handled within the company, and it's actually it's a good exercise in a way for a company who is ultimately going to perform classified work to build the controls in place for the export control side. How do internal engineering drawings need to be marked? Where are they stored? What vendors are you working with? I'll talk a little bit about the challenges of CMMC compliance and NIST 800-171 compliance, which come along with most federal contracts, and ensuring that we don't have an employee, for example, that has access to the network on their mobile phone, go take a vacation in a foreign country, and suddenly bring a document over, or have access a document over an unencrypted network that is export control. You're in dangerous territory there. So, a lot of the folks that we have hired do come from defense contractors, but some don't, and some come in and have very little understanding of export control and are quite shocked when you tell them you don't get to bring your work computer with you when you travel internationally unless there's some compelling reason, and ensuring if they do need to go, you've got a essentially a go bag of sanitized systems that somebody can bring, where they can VPN potentially to access something, but there's no export control data living on that device that might cross boundaries. Data sharing protocols when you're a private investor when you have private investors is a real challenge, because most investors, banks, you name it, they're going to have various non-US persons that might work in those institutions, and you need to ensure that they are handling the data in a way that is not accessible to non-US persons. A lot of investment money comes from international sources. We'll talk about this in the sort of classification arena, but we have had to ask very probing questions to our investors in ways that they are not accustomed to really understand the where the money has come from, to make sure that we don't have potential foreign ownership or control issues, let alone the export side of like when they're shopping around a venture capital fund for a potential investment. We're very careful, for example, not to have any sort of export control data on things like pitch decks or investor decks, because that is also a problem. And so when you work with ex-military folks, it's a little easier, quite frankly, that are founders. But when you work with more other Silicon Valley type startup folks who are brilliant engineers, and could very much care less about ever talking to a lawyer, having to make sure they know what the bounds are for their work, can be a bit eye-opening to them of, hey, you have to be careful in all of these different ways. Even, for example, collaborating with a non-US person on anything of technical substance that may be export controlled. I'll jump into the next one here. So some of the ways in which you look at the compliance strategies, it's early technology classification, jurisdiction determinations. I kind of talked through some of that, right? Implementing the robust export compliance programs, employee training. For most things, this is the case, right? But you honestly cannot do enough training. And the more you get to somebody from perhaps a couple of different angles and a couple of different approaches, right? An in-person thing, maybe a webinar thing, maybe you have them do a kind of gamified test, run people through different scenarios, really train. And even when you train, you still will have mistakes made. And so, understanding also what the avenues are within a company and its compliance controls for if a mistake is made, reporting it properly and handling it properly. And do we need to make any sort of voluntary disclosure to the government, right? All of these things are not usual for an early stage company. And you look at some of the great American tech startups, it was likely many years into their operations before they really had to start to build the kind of robust controls and compliance controls that a space company, particularly a space company focused on national security, has to have right from the start. And so the cost to a company, both time and administratively, but also simply with respect to external counsel and consultants, and the number of people that you need to get help to make sure you're doing it right, is quite expensive. And when people are looking at starting early stage space companies, it's something to really understand that you're going to need to make sure your investors know that your legal budget and your compliance budget is going to be way higher than probably anything they've seen for a company of an early stage status, and explaining why it is the case. Of course, there's a parade of horribles, right? You screw up export control, you've got potential criminal procedures and very expensive penalties that can occur as well. You get into the classified arena, probably most people, if not all on this call, are well familiar with the kinds of penalties that can occur should you either inadvertently or God forbid intentionally misuse or mishandle any sort of sensitive classified information. And I know this is not an export control, but I will bring in, controlled unclassified information, or CUI, an area of great angst and headache, I think, for probably most people at this point that work with government documents. And, understanding the handling process of CUI is also complicated, and where those things live on your server, getting the right, cloud server, right? So we at True Anomaly, we're on the Microsoft Gov cloud. It's like, way more expensive than any other normal cloud, right? So you're not going to be able to go and get your data on, your Joe Schmo's, cloud environment. You're going to have to spend extra money to have the extra secure cloud. All these things factor in to the way in which, a company like True Anomaly has to navigate these traps. Okay, so then of course, what's the point of it all? Um, we're trying to get government contracts, right? So True Anomaly is blessed to be working on a exciting program that it has been publicly announced called Victus Haze. It's a tactically responsive space program. We have other contracts as well with the U.S. government, but the most sort of public one at the moment is Victus Haze. And what does that mean? Well, that means that we are now, working within a environment where companies like my old employer, Lockheed Martin, and others of that, category, they know how to, navigate the complexities of government contracting better than anybody. Well, we're just a small early stage company. It's just me and another in-house counsel. And we are, we're trying to bring the best that we can to the execution of our government contracts and the performance of them, let alone, the lead up for the acquisition side, which I'll talk about in a moment. But navigating, the basics of the FAR and the DFARs is one thing. Meeting standards, like for example, if we were in a more traditional acquisition process, like a cost plus contract, the cost accounting standards, the level of oversight that you'll have through other government agencies like DCMA or DCAA and the auditing side. These are extraordinarily complex, regulatory needs in this regard. I guess I would call them regulatory, or at least contractually mandated. You also don't know what you don't know as a new company, and so it reminds me of that scene in Indiana Jones when he's trying to like cross there's like different platforms you can step on, and if he steps on the wrong one, the whole floor falls down, and that to me is like exact parody the kind of world in which I feel like we confront at times being an early stage company, because we think we know the path, but sometimes our own, our customer doesn't necessarily even know the right approach either on a particular kind of novel framework. And so we're working together. And again, another plug for work with your customer, work with your, the people that are buying the thing, but also the other folks within the government that might have a sort of indirect interest in the performance of that contract, and how you're going to ensure that you put together the right things in the right way to execute on these critical programs in a way that is as good or better than the established defense primes. None of this is easy, none of it's cheap, and it takes a lot of energy and a lot of effort, and I think it's good if you're on the government side to understand and maybe have some grace at times for smaller companies that are doing their best to ultimately solve problems, which is, I think, what we're all trying to do is solve problems for our nation. And how we do that, if we can work together to solve those problems and navigate the traps, we will all end up in a better place. And so, and there is obviously, companies can partner with experienced primes or other, technology integrators. But that is not necessarily attractive in many ways. It runs the cost up, ends up being a traditional relationship that the customer agency may not want to begin with. The whole point of working with a smaller company and an early stage space company is to be able to, leverage the nimble, fast paced way in which they can, deploy solutions. And so, not always necessarily to anyone's advantage, frankly, for these large crimes to be involved in some of these things. But investing in people with expertise in proposal preparation and contract management infrastructure, those are really important. Some more challenges. Again, navigating the FAR, DFARs, understanding the way what's mandatory or not, or what are different options that might be able to attach to a particular contracting opportunity. Are you going to be able to, for example, in your BD team, working with counsel, potentially, shape an opportunity so that instead of a standard acquisition, you're looking at something like an other transactions authority uh, contract, which some of you are likely very familiar with. How can you help the customer get to that side rather than the traditional acquisition structure? And why does it make sense or not make sense in a particular scenario? Meeting cost accounting standards in accounting practices is quite difficult, requires an entire team of finance and accounting professionals. Well, if you're an early stage startup and you're trying to provide a less expensive, fast solution to the US government for something, and yet you have to go hire 15 accountants and finance people and train an entire team of how to manage time and build the right building codes and all of these pieces of overhead, then we're right back to slowing down the basics of where we need to be as a nation to that. It's essentially just goes backwards. Cybersecurity requirements, on the other hand, are 100% critical, right? So not just complying with what are called the CNMC standards, but deploying a robust cybersecurity infrastructure is indeed quite costly, but ultimately 100% necessary. One of the things that we as a company have done is we have leveraged some, there are a few avenues for essentially getting help from our friends in the federal government in this arena through whether it's FBI or through the Air Force OSI side. This is yet another example of working together. We might be able to get to a state of better security faster if we work together with our partners in the government rather than trying to do it all on the outside. And plus, not only the competence and the capabilities in this arena are often such that it's so expensive to try to field them as an independent company that we honestly we need help, right? We need help from the largesse of the U.S. government to help deploy and help understand the way in which we can defend the company's cybersecurity infrastructure. It's an area of great angst for me and many people in our company of trying to do this as fast as possible, knowing that we have a publicly stated mission out there that has a national security focus, and therefore we are directly a target to some of the most sophisticated nation state actors for interference in what we're doing. And overcoming regulatory hurdles and managing the compliance costs. I'm fortunate that our team understands compliance and the costs and the need for effective legal servicing as well. And but at the same time, the costs really are extraordinary. And if I'm sitting in the shoes of like, how do I foster an industrial base of startup companies to do really innovative work in the national security arena? One of the worst things that you could do is layer on levels of different layers of bureaucracy and compliance that you're not going to get a garage startup that founded Apple or Google. It's very hard. And we risk as a nation really tying the hands of our innovators if we can't get this right. And there's a lot of work to be done. Jump right into security clearances and classified work. Obviously, some contracts in progress projects will require personnel with security clearances, and getting a facility clearance may be necessary. It is necessary. And the investment side, and I alluded to this before, but the Committee on Foreign Investment in the United States, CFIUS, is going to take a look at foreign investments as well from a different angle. But CFIUS has specifically tied up a couple of space companies that didn't quite get it right with their foreign investment. And that's before you even get to the DCSA review of a thing like a facility clearance. And of course, then developing a security program aligned with the National Industrial Security Program is time-consuming, complex, and often those skills, you can't just snap your fingers and be like, all right, let's deploy a fully robust security program that aligns with things that took other companies and can take other companies years and years and years to develop. Well, if you really want to get this in the hands of the warfighter fast enough, we got to do it faster than anybody's ever done it before. And to do that, not only requires sort of a level of understanding and partnership with customer base and with the regulators, but also I think ultimately we should hope that we will see even top cover from the political side of how we get American companies the ability to innovate in a classified arena faster. And it's just as simple as that. And how do we do that without screwing it up? Yeah, because you're going to hear, well, all this stuff takes time for a reason. Well, understand, but our adversaries aren't waiting for us. So structuring operations, right? So corporate governance here from kind of classic general counsel side is important, ensuring that you have your compliance and licensing processes together, having cross-functional teams. It is, nobody can do this without a deeply integrated legal team that's working with engineers, working with security, working with the people team, working with every aspect of the company, so that you have a culture of compliance, a culture of governance that, and controls that have, even in the environment where we got to move fast, we got to break things, we got to get this in the hands of the U.S. Space Force, right? Well, it takes leadership from folks like myself. It takes leadership from our CEO and our entire executive team, all the way down to the individual contributor turning wrenches, building a satellite. The culture has to be that of utmost professionalism, utmost seriousness. We are not building a dating app. I'll say it again, we're not building a dating app. These are some of the most complex technological systems in one of the most complex regulatory environments in one of the largest bureaucracy on the face of the planet, facing, an environment where the stakes are ultimately, the way we view it, life and death for the folks that are going to be on the other end of needing our systems to support their missions. And so that culture of sort of solemn seriousness is critical. And I've joked that maybe we probably have a little less fun than your average startup. We do have a ping pong table in the office, but we're not like your we're not like the WeWork startup, if you saw that movie or that HBO show. All right, almost through here, and then we can get into some questions. So how do you drive innovation? It's really kind of what I've been saying, right? It's fostering. It is possible to have a culture of innovation, of technological, the world is open to us, but understanding the balancing act of, for example, I have my copy of space law quick reference guide here. Oh, there we go. Right. I actually keep this on the side, and of course we can never forget Article 4 of the Outer Space Treaty. Right. We're not deploying weapons of mass destruction on orbit. At least we're not building it as a private company. That being said, there are things that we have to think about. Right. We have to think about considerations of national policy, of international treaties, when we look at what kind of products we might develop for the customer. It's not every day that a startup type company has to think about international treaties, but we do. And so, having this sort of systemic and cross-domain understanding of all the ways in which the company's mission and products can ultimately interface with and bump into some very heady critical issues with respect to international policy. It can at times be a bit overwhelming, and we have to step back and say, okay, like we don't have to do all this alone, but we do need to understand also how our own government thinks about what it wants and what it needs. And I suggest to anyone that is in the arena, right? Commercial Spaceflight Federation, these industry groups, these are great ways to kind of plug in and understand where some of the wickets are. Satellite Industry Association, Confers is an association focused on the kind of in-space inspection and RPO capable systems that include those like True Anomaly, but also really include debris removal companies that might be trying to do just purely civil type things. But obviously, if you're a debris removal company, you got a little robotic arm that can grab a piece of space junk. It's not rocket science to figure out how that could be used in a way that might violate a treaty or something. So lots to consider. I threw in a bunch of links here in one place. I actually wish somebody had put these links together when I first got into this world, because you can actually learn quite a bit just reading through now a lot of the resources that are available that have been put out even in the last year by various federal agencies. And so these are useful links. And my contact information is here, and you can connect with me on LinkedIn as well. So for that, I think we have a little time for some questions.
Well, Mr. Linton, thanks so much. That was a fantastic and insightful peek under the hood, to all of the challenges that you're facing as a space, national security startup company. My mind is blown, and I have so many notes of things I need to look up soon. We do have a few questions, but I'll note we're a little bit over time. Do you have time still to do a few
I do.
questions?
I apologize if I went a little long.
Oh no, it's fine. I think it's absolutely fine. But just in case anybody does need to step off before we do a couple of questions, thank you all for joining. We'll have this is the end for the year for the Lit Work series, but we'll have some new ones starting in January. If you have any topics yourself that you would like to propose, feel free to reach out to me. And I apologize, I didn't get the entire video recorded. I didn't start it for the first minute. But just to reiterate, all the comments from myself or any of our speakers on the Litwork series are their own comments, don't necessarily represent any governmental agencies, and none of our presentations reflect any sort of government endorsement, actual or implied, of any private companies. So just throw that on there. But Mr. Linton, to get into a couple questions, and you mentioned a little bit about orbital debris removal. And I know this isn't necessarily what you all are doing, although I can imagine there's some applications of what you're doing in the orbital debris removal space. But the question is, do you think that space startups in that category are anticipating some sort of legal developments or soft law developments that maybe de-risk those investments? Because it seems like there's a lot of legal risk. And I think maybe there's some parallels too in that legal risk and de-risking that your own company is dealing with. Could you share your thoughts on that?
You bet. There is a pending rulemaking through FCC for ISAM activities. And I think we should see a revision to the proposed rule. My understanding is sometime maybe in the next month or so. That rulemaking is more squarely focused on the commercial side. And so I think there are a lot of things that might provide clarity, and would encourage folks to take a look at it. It certainly would help, again, at least in the FCC arena. Where we don't have clarity, right, for those kind of companies is if you are like, not thinking about national security at all, right? You're just thinking, man, I want to be a space sustainability person and I'm going to clean up this mess that we have on orbit in different places. How do they know what the DoD policy is for, RPO operations, right? How do they know, right? So how do they know whether or not they might be accused of engaging, because ultimately, if they're authorized by the United States, how do they know that they might not be accused of acting on behalf of the United States in an aggressive way toward a foreign satellite? And but for building relationships within the agency, like there's not like a good way for people to say, okay, here's the number I call, right? Here's who I talk to when I want to make sure that our civil space activities are not interfering with the way in which our military really wants to try to drive the policy. I don't know if that helps, but
Yeah, that's fantastic. And you talked a lot about the increased investments that you need to face at the front end on the legal and regulatory compliance side of things. And then I really appreciated your comments on how the government has an interest in this too, right? We need to foster this innovation, but like you said, you're not just going to have a garage startup. How what would you ask of the government, I guess, if you had your druthers? What should the government do
sure.
to help you, or and help companies similarly situated?
I do think that elements in the novel space framework that was proposed to the National Space Council last December are a terrific start. And that so that's my number one plug there. I think that having that being said, having a sort of military seat at the table in a way, or a connection point, a friendly connection point, right? I think would be very helpful, because I think, it's especially like your average technology person or engineer, they're afraid to go talk to Space Force or Air Force, right? They don't even know they don't know who to call. And so I think, some transparency and like kind of the greater good of cross domain partnership would help. But I do think the novel space activities framework is a great start, and we should really also encourage, as there are some legislative proposals in Congress for mission authorization. We should really focus on encouraging our legislative branch to provide needed clarity with respect to mission authorization that is not such a sort of patchwork of agencies, and can help sort of bring it all together into a single point of contact for companies to say, here's what I want to do, and here's where I go to figure it out. And here's an ombudsman within the government that helps me navigate, right? That sort of a thing is how I would suggest it.
And it kind of sounded like you were suggesting NOAA is starting to play that role in a lot of ways, and running the traps across the different agencies. Do you see them taking on a bigger role over time? Is that a good thing?
I think so. Larger than even above NOAA. There's a lot of talk about, Office of Space Commerce taking more of this, and I think that makes a lot of sense for a lot of reasons. If you're a spacecraft that doesn't do any sort of remote sensing or NEI, you're not going to have to go get a NOAA license, and so that the process works well if you're doing that kind of a thing. But there are companies that don't, and so they're having a sort of larger entity above it, and I do think it makes a lot of sense to go through the Office of Space Commerce, because that's, even if there's a national security nexus, we have a policy that as a nation now, right, that says we want to try to leverage commercial platforms even for DoD certain enumerated DoD missions. So, it kind of makes sense that it really starts at the commerce side.
And we actually have there's a hand raised here. Looks like Mr. Ligger from Rand. So I'm going to go ahead and allow you to talk. If you want to go ahead and unmute yourself, go ahead.
Great. Can you hear me?
Yes.
Great. Yeah, thanks very much for the presentation, Matt. Really interesting. I'm curious, because we do some research in this area. And as you went through, it was really interesting as you went through a lot of the examples, taking one at a time, you understand the rule and you're like, okay, that rule makes sense. Yes, you don't want data on a phone or a laptop being hacked into by an adversary. You want to make sure that whatever company is doing this work is set up to where they can have a MOSA for a SCIF if needed. Like taken on their face, they all seem reasonable. Is part of the problem, from your experience, or one of the major issues, that these agencies simply are not staffed to do the compliance, enforcement, and adjudications quickly enough? In that case, it's not really about the rules. It's really about the resourcing that you've kind of alluded to throughout.
It's a great question. Thanks, Doug. I actually think it's a little bit of both, in the sense that absolutely, I feel for. I mean, I was a government person myself. I was at DOL with shoestring budgets, right? I very much appreciate that, some of the regulatory problem here is just due to lack of resources, lack of personnel.
Right.
That being said, I think it's the integrated nature of the different levels of review as well that are challenging. And so, the fact that we have such two entirely disparate regimes and agencies, both like FCC and NOAA, for example, it just screams out of like that there's inefficiency there. Like, to the extent that somehow we're able to synthesize and, have folks work together and not, for example, I can't give you a specific example right now, but I'm sure that there is overlap in terms of like the things that they are doing internally within these agencies to run the traps. And, how do we, and again, this is part of that novel space framework as well, but how do we like make it more efficient by bringing teams together? I do think is necessary. Money is always a need here, though. And yeah, I mean, I'll give a shout out if anybody, wants to give any of these agencies more money to hire folks. Please do. They need it. Yeah.
Yeah, no, thanks. Great answer. Really appreciate it.
Okay, well, thanks so much again, Mr. Linton. I think we'll call it here out of respect for your time, and I know people probably have places to go, but I know we have several requests. I think I've gotten 4 emails in the time we've been here and multiple chats asking for the slides.
I will get them over to you.
Thank you all, and then if you could, do you think you could copy paste into the chat the links maybe, and then people could just pull them here if they're still on. But then I will, I'll forward out the slides. We'll really appreciate it. What a great presentation, really insightful. Like I said, a really great peek under the hood. With that, I just want to say again, this is the last presentation for the year from the lit work here at USAFA. We have in the spring a small series on nuclear fusion plans, so we hope to see all of you there. And again, there will be some obvious ties into space. With that, I hope everyone has maintains sky high spirits and that your holidays are out of this world. With that, we'll sign off here from the Academy. Thank you again, Mr. Linton, and thanks everyone for joining. We'll hope to see you soon.
Thank you, sir. Thank you all. Happy holidays. I did try to paste it, but it wouldn't copy the links. So I will send over the PDF of the presentation, and it should work fine for you.
Okay, thanks so much. Appreciate it.
Okay. Thank you. Bye-bye.
Bye-bye.